Hello, everyone. Thank you for attending today's webinar, The Big Bang, When the Worlds of Energy Law and Bankruptcy Law Collide. I'm Cheryl Kelly. I'm a partner in Thompson Coburn's Bankruptcy and Financial Restructuring practice. Joining me in presenting this program are David Farrell, also a partner in the firm's Bankruptcy and Financial Restructuring practice, and Meg McNaul, a partner in our Energy practice. Both David and I office in St. Louis, and Meg practices out of our D.C. office. Additional information regarding each of us is found at the links provided at the end of the program PowerPoint. Please note the following with respect to navigating the program and continuing education credit. We did provide materials for the program. A copy of today's slide deck is available in the resource widget or icon at the bottom of your screen. By hovering over a particular icon or widget at the bottom of your screen, the name of the icon should appear. Should you have questions, these may be submitted through the Q&A widget at the bottom of your screen. We will try to answer these questions during the webcast, but if a fuller answer is needed or we run out of time, we will answer them later via email. Should technical difficulties arise during the program, these may be addressed by accessing the Help widget at the bottom of your screen. Clicking F5 may also help with addressing technical difficulties. With respect to continuing education credit, please note that CLE is awarded on attendance for the entire 60 minutes of the program. From time to time, you will be required to click a pop-up screen to reflect your continued engagement in the program. The webinar is accredited in California and Illinois for an hour of general CLE credit and in Missouri for 1.2 hours of general CLE credit. At the end of the webinar, please complete the CLE certification form. Your certificate of attendance will be emailed to you generally 2 hours after the presentation. Please also complete a survey. We value your opinions and appreciate your participation in the course. Before launching into the program proper, we thought it would be helpful to provide a brief overview of the program coverage and the approach that we will take. The centerpiece of the program is a discussion of 4 leading federal court decisions concerning the question of who is the proper authority to determine whether a debtor in bankruptcy may reject or be excused from performing a power purchase agreement. Is that authority the Federal Bankruptcy Court, or is it the Federal Energy Regulatory Commission, also known as FERC? And I think from henceforth we will refer to the Federal Energy Regulatory Commission as FERC. The 4 decisions we will discuss include the Fifth Circuit's 2004 decision in the Morant case, the Southern District of New York's 2006 decision in the Calpine case, the Northern District of Ohio Bankruptcy Court's decision in the First Energy case, which is now on appeal with the Sixth Circuit, and the decision by the Bankruptcy Court in early June of this year in the PG&E Chapter 11 proceeding pending in the Northern District of California. As a prelude to the substantive discussion of the 4 decisions, we will provide a brief overview of energy law and bankruptcy law principles that are relevant to understanding the conflict in question. Because we have a diverse audience for this program, some of whom are more familiar with energy law concepts relevant to the issue, and some of whom are more familiar with the bankruptcy law concepts relevant to the issue, we thought we should provide at least some background to help familiarize the audience as a whole with the varying legal concepts that shape this developing conflict between the bankruptcy court and FERC. Finally, we plan to generally relay the material by interviewing one another relative to the subject matter. Hopefully this format will be engaging and useful for you. So with that, we're going to turn to the substantive portion of our presentation, and David and I will interview Meg in an effort to relay the key concepts relating to energy law that are relevant to understanding this power struggle between FERC and the bankruptcy court that is associated with rejection of power purchase agreements. After that, Meg will in turn give us an interview on the relevant bankruptcy concepts. So with that, we will turn to our substantive presentation.
Thank you, Cheryl, for that introduction. Hello, everyone. This is David Farrell. I'm going to start things off by asking Meg. Meg, could you provide us with an overview of what FERC is, the policy behind its establishment, and the general scope of its regulatory powers?
Sure, and hi, everyone. So FERC is an independent agency within the Department of Energy. It was created by the Department of Energy Organization Act in 1977, and it's the successor agency to the Federal Power Commission. Appeals of FERC decisions are subject to review in federal appellate courts, and FERC commissioners and staff are frequently asked to testify to Congress on various issues within FERC's regulatory purview. FERC has 5 commissioners. The commissioners are selected by the President and confirmed by the Senate. No more than 3 of the FERC commissioners can be from the same political party, and so as a practical matter, that means generally 3 of the commissioners are from the same political party as the President. The FERC chair is also designated by the President and sits pursuant to the President's authority to designate the chair in that role. FERC is organized into offices that perform a wide range of functions related to the industries that FERC regulates. FERC has more than 1,400 employees, which include attorneys, engineers, accountants, scientists, and other professionals and administrative employees. During fiscal year 2019, FERC's budget is approximately $370 million. FERC is funded from congressional appropriations, but it actually receives filing fees and assesses annual charges to the entities that it regulates. So the fees and the charges that FERC collects essentially fully offset its appropriated budget amount. And so what we have seen that means is sometimes when there is a federal government shutdown, very frequently FERC can continue to do its business. Currently, FERC has 4 seated commissioners. Each of the commissioners serves a staggered 5-year term. The chair is Neil Chatterjee, who previously served as an energy advisor to Senator Mitch McConnell. In order to take official action, FERC needs a quorum of 3 or more commissioners, but the commission is able to delegate some decisional activities to its staff. FERC regulates most electric and natural gas utilities and pipelines. More than 50% of FERC staff work on electric industry issues, and remaining activities are split somewhat evenly between the oil and natural gas programs that FERC conducts and its hydroelectric programs. The primary statutes that FERC is charged with administering include the Federal Power Act, the Natural Gas Act, and the Interstate Commerce Act. Since we're talking today mostly about issues within the electric industry, I'll focus on FERC's authorities related to electric utilities. Its main statute from the electric sector is the Federal Power Act. Under the FPA, FERC regulates the rates, terms, and conditions of wholesale power sales in interstate commerce and electric transmission. It also performs activities like reviewing mergers and acquisitions by electric utilities, monitoring the energy markets, enforcing electric utility reliability requirements, licensing and inspecting hydroelectric projects, administering accounting and financial reporting regulations, and supervising market conduct by electric utilities. FERC's regulatory activities under the Federal Power Act are primarily for the purpose of protecting the public interest by ensuring the availability of electric service at reasonable prices. Part of FERC's role under the statute and what animates its decisions are FERC's objectives of ensuring reliable service at just and reasonable rates. As I mentioned a moment ago, FERC regulates wholesale electricity sales and transmission in interstate commerce. This means that FERC regulates the rates and the charges for these services. Its jurisdiction over wholesale electric sales and transmission is exclusive. And in addition to regulating rates, FERC also regulates the rules, regulations, practices, and contracts for wholesale electric sales and for electric transmission. The Federal Power Act provides that these rates, terms, and conditions of engaging in wholesale sales and transmission must be just and reasonable. In general, a wholesale power sale means a sales transaction of electricity from one utility to another. When the purchasing utility intends to resell that power to another utility or an end-use customer like a homeowner or a business. An example of a sale for resale might be one utility with an electric generating plant selling some of the output of that plant to another utility, which then uses that power to supply the energy needs of its customers. A A wholesale energy sale can also refer to sales transactions that take place through the regulated energy markets that operate in many parts of the country, which we'll discuss in a minute. FERC's regulation of transmission generally includes the high voltage lines that move power in bulk from generating facilities where power is produced to substations where power voltages are stepped down for delivery to end-use customers, again, homes and businesses. The smaller lines that bring power from transmission substations to homes and businesses are referred to as distribution lines. FERC generally does not regulate distribution services. Instead, distribution service and sales to retail customers are regulated by the states and by local government.
Meg, thank you for that overview of the history and summary of FERC and its power and authority. So you indicated that FERC regulates wholesale power sales and transmission. How do utilities obtain the power that they need in order to supply their customers?
Sure. Thanks, Cheryl. The answer to that question can really vary from utility to utility and region to region of the country. Some utilities own generation resources, and they use those resources to generate power to supply to their customers. Sometimes utilities will purchase power through a FERC-regulated wholesale market. A utility might do this to make up a small increment of power above and beyond what their own resources can supply, or it might make market purchases for a larger sale of power supply. It can really vary. Utilities may also enter into bilateral power purchase agreements to obtain electricity from entities like another utility, a generator owner, or from an entity that markets power that comes from a portfolio of contracted resources. These types of contracts sometimes require scheduling and settlement of bilaterally purchased resources through an energy market. These are the various regulated markets throughout the country. The FERC-regulated organized markets include the California ISO, the Southwest Power Pool, the Mid-Continent Independent System Operator, PJM, and the New York and the New England ISOs. In simple terms, these markets operate like exchanges. Even though there are organized markets, keep in mind that utilities might still need bilateral contracts in order to fully manage their energy supply. In other parts of the country, like the Pacific Northwest or the Southeast, there are still markets for electricity, but the markets are generally conducted through bilateral contracts or multi-party agreements instead of through the organized exchanges.
Meg, this is David Farrell again. We understand that some relationships may be governed by tariffs and some by written agreement. Could you explain why that is and the ramifications of the differing modes of governing relationships?
Sure. So a tariff has generally applicable rules. FERC approves these rules before they are made effective, and FERC will sometimes issue orders or rules setting forth specific terms that must be included in all tariffs. These are often referred to as pro forma provisions. For example, FERC has uniform policies around activities like transmission planning, and unless FERC allows an exception, these pro forma terms must be included in transmission tariffs. A power purchase agreement is also subject to FERC's jurisdiction. These are bilateral or sometimes multi-party agreements for the sale of electricity products like energy or capacity or ancillary services. Power purchase agreements can be short or long-term, and they are sometimes used to help obtain financing in order to develop a generation facility, in which case the agreement would have a longer term. Most organizations have moved away from filing each and every contract in which it sells power that's subject to FERC approval. Instead, what most utilities do is enter into power sales agreements pursuant to market-based rate authority. That means that FERC has reviewed whether the particular utility is in a position to exercise market power. And if a utility doesn't have market power or has mitigated market power, then these utilities adopt tariffs outlining the general rules for sales and contracts to sell power at market-based or negotiated rates. But the tariffs don't themselves contain prices. Again, those are negotiated. Instead of filing all market-based contracts relating to power sales for FERC review, what these utilities with market-based rate authority do is provide FERC with periodic reports listing their transactions. Once the rates, terms, and conditions of service set forth in a tariff or in a FERC jurisdictional agreement are approved or accepted by FERC, this becomes what is called the filed rate. Utilities are not allowed to charge rates other than the filed rate unless they file for and obtain FERC approval to change that rate.
So, Megan, the bankruptcy matters we will be discussing, FERC asserts concurrent jurisdiction to weigh in on the determination and the impact of a rejection of power purchase agreements. Outside of bankruptcy, how does FERC typically handle the exercise of its jurisdiction, and how would it typically address a breach of contract matter?
So when there's a dispute pursuant to a power purchase agreement, FERC has issued orders that state for breach of contract matters it actually has concurrent jurisdiction with the courts to resolve disputes. So if a party files a complaint at FERC alleging breach of a FERC jurisdictional contract or tariff, it's up to FERC to decide if FERC will resolve the dispute. If FERC decides that they don't want to exercise jurisdiction over the complaint, then the parties go to court in order to litigate their dispute. But again, that decision is solely up to FERC. FERC has a test that it applies in analyzing whether it should or will exercise jurisdiction over a breach of contract. The test looks at several factors, including whether the Commission has special expertise to resolve the issue, whether there's a need for uniformity in interpreting the type of question raised by the dispute, and whether the case is important to FERC's regulatory responsibilities.
Meg, are there instances where FERC might be able to modify parties' contracts outside of bankruptcy?
Yes. FERC is allowed to direct changes to tariffs or to power purchase agreements. But under the Federal Power Act, FERC first has to find that the existing tariff or power purchase agreement is unjust or unreasonable or unduly discriminatory or preferential. If FERC makes these findings, then FERC is allowed under the Federal Power Act to issue an order setting the revised rates, terms, or conditions of service. There's an important limitation on this, though. For bilateral contracts or multi-party contracts, such as power purchase agreements. This limit is what is referred to as the Mobile Sierra Doctrine. What Mobile Sierra provides is, and it's based on the names of two important Supreme Court cases that are cited there, but what it is a presumption that the rates in a bilaterally negotiated agreement for the sale of electricity products between two or more sophisticated parties are just and reasonable. And unless required by the public interest, such contracts are not usually modified. The public interest standard is thought of as being a very difficult standard for utilities to meet, with one court kind of famously describing the public interest standard as practically insurmountable. In addition to ordering changes to unjust and unreasonable rates, FERC has other remedies at its disposal. For example, FERC can issue orders requiring disgorgement of profits or return of the time value of revenues that were inappropriately collected. FERC also has civil penalty authority. And finally, the Federal Power Act provides that FERC orders can be enforced by the district courts. So that means that if a party doesn't comply with a FERC order, then FERC can ask a federal district court to issue relief such as an injunction or a writ of mandamus, and that's also in the Federal Power Act. Right. David, that's really the end of my overview of FERC. Are there any more questions?
Not at this time, but thanks for the wonderful overview of energy law. And I guess now we throw the ball back in your court, Meg. Do you have any questions about bankruptcy?
Definitely. So what are the major policy goals that bankruptcy law is designed to promote?
Meg, the bankruptcy laws are federal law governed by Title 11 of the United States Code. The Bankruptcy Code is known as, is found in Title 11, and there are generally three primary objectives that are set forth or accomplished by Title 11. The aim of the bankruptcy laws are to provide financially distressed parties with a means of obtaining a fresh start. Additionally, the bankruptcy laws aim to provide creditors with a fair and equitable distribution with respect to the value of the financially distressed parties' limited assets. And then also the aims of the law are to maximize the overall recovery to the stakeholders, typically the creditor body as a whole in the case.
So how do corporations and other business entities obtain a fresh start under the bankruptcy laws?
So Chapter 11, which is part of the Bankruptcy Code, is the primary means by which a business enterprise would obtain the fresh start in bankruptcy. The aim of Chapter 11 is to take a break, if you will, seek respite from your creditors and others and formulate a plan by which you can then emerge from bankruptcy. The debtor proposes to restructure its existing debts and emerge out of the bankruptcy as an ongoing enterprise. The debtor seeks to confirm a plan, which is a roadmap, if you will, for managing the pre-petition obligations of the past and then moving forward under that roadmap to do its ongoing business. Once the plan is proposed and then ultimately confirmed by the bankruptcy court, then the creditor's existing debts as of the time of the bankruptcy are deemed discharged and then replaced by those obligations as they are now set forth in the plan. And another interesting aspect about Chapter 11 is that because it's an ongoing exercise, if you will, to restructure the debtor's business and move forward under new and better terms, the Chapter 11 debtor its existing management would typically remain in control of the debtor's affairs. That's unlike a Chapter 7 liquidation where the plan is just to wind things down and distribute assets. There you would see a Chapter 7 trustee appointed to manage the affairs of the debtor. There are times a Chapter 11 trustee might be appointed in a reorganization proceeding, but that's not typical. There are certain things you'd have to show to have that happen. And then also, during the first 120 days of the case, and sometimes upon an extension thereafter, the debtor's management has the exclusive right to propose this Chapter 11 plan that would establish the roadmap for dealing with the claims of the past going forward.
So what, if any, special protections or powers do companies obtain by filing for Chapter 11?
So the Bankruptcy Code provides a number of tools to buy time and space as a debtor to achieve that fresh start and the other goals that we talked about a little bit ago. And there are two particular tools that are particularly of relevance to the subject matter of today's presentation. One is the automatic stay that is covered under Section 362 of the Bankruptcy Code. The other is the debtor's power to reject executory contracts under Section 365 of the Bankruptcy Code. And just briefly, the automatic stay provides breathing room for the debtor so that it has an opportunity to sort through its affairs and hold at bay the different creditors and others at the door that are seeking repayment on their prior pre-petition obligations. The automatic stay prevents any ongoing, not every, but most ongoing collection activity against the debtor and prevents parties from exercising control over the debtor's assets. The automatic stay is called automatic because the Bankruptcy Code section I mentioned, Section 362, provides for this stay to automatically go into effect upon the filing of a bankruptcy proceeding. So the stay is a statutory injunction or a bar, if you will, from collection activity and activity to gain control of the debtor's assets. The other thing to know about the stay is that if you are not excluded from its impact, which is, there are a few limitations as far as, or few exceptions to the automatic stay, but if you are subject to the automatic stay and you violate it, the bankruptcy court can impose contempt sanctions against the violator.
So, Cheryl, are there any limitations on the scope of the automatic stay?
There are, and one of the key exceptions is relevant to our program today, which is that typically governmental units that are exercising and enforcing their police and regulatory powers are exempt from the automatic stay, meaning that they don't have to go into bankruptcy court to seek relief. The bankruptcy code already provides that this exercise of police and regulatory power is an exception from the operation of the automatic stay. Also worth noting is a provision in the United States Code that's cited in our materials, 28 U.S.C. Section 959, which makes clear that a debtor operating under the protection of the bankruptcy court has to abide by all applicable non-bankruptcy laws. And when we get into the meat of the cases, you're going to see that this theme is relevant, or these concepts are relevant to those cases. Additionally, worth noting is that the bankruptcy court is a court of equity, and there's a provision in the Bankruptcy Code, Section 105, that gives the bankruptcy court broad power to issue any order, process, or judgment that is necessary to carry out the provisions of the Bankruptcy Code. So you can imagine with such a broad statute that it's a place that many seeking relief would run to try to find a way to take advantage of that statute. And pursuant to Section 105, there are at least some bankruptcy courts that have found that there may be limitations, notwithstanding the code provision that gives police powers, the exercise of police and regulatory powers, an exception from the operation of the automatic stay. Section 105 has been employed to, in fact, put the brakes on the exercise of those powers by some courts.
So, Cheryl, with respect to the ability to reject in bankruptcy executory contracts, are there any other rights or powers that a company obtains by filing for Chapter 11?
So we talked about the two key some of the benefits of bankruptcy, the automatic stay being one, and then the power and ability to reject executory contracts. And so in this instance, for the purpose of this presentation, that power is an important one to take into account. An executory contract, that's not a term that you'll see defined in the bankruptcy code, but through the courts, that term has been defined to mean a contract where each party has ongoing obligations that neither has performed to such a level that if one party was to breach its obligations, that would give rise to a breach of contract claim by the other party. So an executory contract is not one where one party is fully performed and the other one is now in the seat to give counter performance. It's one where each party has ongoing obligations and neither has fully performed, and either by a breach would give rise to a breach of contract claim in favor of the other. With respect to the power purchase agreements that you've talked about and that David will talk about in more detail in connection with the cases, there's no question that those agreements are in fact executory and that they would they're agreements where there are ongoing obligations during a period of time, and that those would be subject to the operation of Section 365 of the Code. So as I said, Section 365 authorizes debtors to reject executory contracts to which the debtor is a party, and the power purchase agreement is such a contract.
So what happens if a Chapter 11 debtor is authorized to reject an executory contract?
So if there is a rejection of a contract, that relieves, it's deemed a breach under the current view of the Bankruptcy Code section. That breach then gives rise to a claim for pre-petition damages, and we'll talk about that in a minute. But the debtor then, once it's rejected the contract, has no ongoing performance obligations under the contract. The contract is not void or terminated or rescinded. Rather, as noted by the Mission Product Holdings case that's cited in the material, that breach is, or that rejection is in fact a breach, and so there's a claim for damages. The fact that the contract is not terminated or voided may give rise to various arguments then as a result of that sort of characterization of the effect of a breach. Again, the consequences of the rejection is that the debtor gets to get out of its obligations. The counterparty then has a claim, a pre-petition claim for damages. The ongoing obligations that a counterparty might provide to a debtor might be subject to an administrative priority claim, but that's not the kind of claim we're talking about here. The breach of contract gives rise to a pre-petition, typically unsecured claim unless the counterparty got some sort of a security. So you stand in line, in other words, for the breach claim at sort of the end of the line with the other unsecured creditors.
So how does a bankruptcy court decide if rejecting an executory contract is permissible?
So the standard that's developed in the courts is the business judgment standard, and essentially a debtor is authorized to reject a contract, and it's permissible that it does so if in the sound exercise of its business judgment that decision can be justified. It's pretty hard not to meet the business judgment standard because if the debtor can show that it's bound by a contract that provides for above market performance, then that would be a justifiable business reason to seek to reject the contract. We do note, and won't go into much detail here, that there are some bankruptcy courts that might fold in some other criteria as to beyond the business judgment rule as to whether the rejection is permissible, such as public policy or perhaps the effect of the rejection on the counterparty.
So what is the scope of executory contracts that can be rejected by a Chapter 11 debtor?
The scope is generally that almost every executory contract is subject to rejection under the standards of 365 of the code, and we cite a case as standing for that proposition. Even collective bargaining agreements under the right criteria can be rejected in bankruptcy.
Are there any limits or qualifications at all on rejection?
There are some explicit limitations that are provided for in Section 365, and we list them here. We won't bear down on the details of these, but there are some limitations. The key point here is that there's no explicit exception or qualification in the Bankruptcy Code regarding the Chapter 11 debtor's rejection of a power purchase agreement.
Does the Bankruptcy Code at all speak to the ability of a regulatory body like FERC to regulate the cases of Chapter 11 debtors?
So there is a provision in Section 1129 of the Code. This isn't the rejection section, now note, that requires that in confirming a Chapter 11 plan, the debtor has to show that the rates it may use in its plan have been approved by whatever regulatory commission or governmental body has jurisdiction over that debtor. The debtor can't just, take action that flies in the face of the regulatory scheme that governs its affairs. Either the plan has to comply with those regulatory demands or show that any sort of a rate change, for example, is conditioned on such approval being granted.
Okay, Cheryl, thanks very much for the overview of bankruptcy law. I think we're going to spend the remaining time we have left addressing kind of the issue du jour, and that is whether a bankruptcy court can authorize a Chapter 11 debtor to reject a power purchase agreement, in other words, an agreement regulated by FERC, and thereby, by using that rejection power, relieve itself of its ongoing obligation to continue to perform under that power purchase agreement. As Cheryl noted in the introduction, there's really four kind of recognized leading cases on these issues. So we'll briefly cover all four of these cases. We'll start off with the first and only circuit decision currently on the issue. We anticipate, as I'll mention in more detail in a minute, we anticipate some more circuit decisions. But at this moment in time, we only have one circuit decision, and that's from the Fifth Circuit way back in 2004 in the Mirant Court bankruptcy. And just to provide a little bit of background on this case, Mirant was a large power producer that filed for bankruptcy back in 2003 in the Northern District of Texas. And at the time, Mirant was a party to a series of PPAs under which it was obligated to purchase electricity at rates that were above the then current market rates. And so immediately upon filing for bankruptcy, Mirant petitioned the bankruptcy court to allow it to reject certain of its PPAs. Now, at the same time, Mirant was concerned that FERC might try to wrestle jurisdiction over the rejection question away from the bankruptcy court, because FERC had successfully done that in a case earlier in the year involving an unrelated company called Energy. So in order to prevent that event from happening, Mirant asked the bankruptcy court to enjoin FERC from taking any further action in the matter. And so the bankruptcy court is receptive to that request for relief and enters a preliminary injunction against FERC. But however, the bankruptcy court, the district court, to which the bankruptcy court essentially functions as an adjunct, the district court withdrew that issue away from the bankruptcy, that issue of the bankruptcy case away from the bankruptcy court, and it ended up vacating the bankruptcy court's injunction and dismissed Mirant's request for rejection. And the district court essentially ruled that the issue of whether Mirant could get out from underneath its PPAs was something that was exclusively an issue for FERC to decide. So Mirant obviously was not happy with that determination, so it appealed up to the Fifth Circuit. And the Fifth Circuit ultimately ended up siding with Mirant and held that the bankruptcy court could decide whether to allow Mirant to reject its PPAs and get out from continuing to have to perform under those PPAs. So the first issue that the Fifth Circuit tackled was Mirant's proposed rejection of the PPAs, did that represent a collateral attack on the filed rates? Because as Meg referenced, certainly FERC's position is, and the general proposition under the Federal Power Act is, no court should engage in collateral attacks of the filed rates. That's something that's exclusively within the jurisdiction of FERC, and if you're not happy how FERC handles that issue, your only recourse is to ask for review of the FERC determination before a court of appeals. So the Fifth Circuit first had to tackle that issue of whether rejection was a collateral attack on the filed rates doctrine. First of all, the court focused on a point that Cheryl made earlier, and that is that if you look through the bankruptcy code, there is no exception to the rejection powers with regard to FERC-regulated contracts. So that was one point that the Fifth Circuit focused on in ruling in favor of Mirant. With regard to the fixed rate doctrine, the Fifth Circuit looked at the fact that even in a rejection situation, that the filed rates will still be fully honored because the non-debtor counterparties to those PPAs will be entitled to assert claims against Mirant's bankruptcy estate, and those claims will be based on the filed rates. So from the Fifth Circuit from their perspective, the filed rates were being fully honored, so no collateral attack or intrusion on the filed rates. And then the Fifth Circuit, with regard to that same point, went out of its way to note that in Mirant's particular case, again, Mirant was the purchaser under these PPAs of electricity, and Mirant made the showing that it really had excess capacity in terms of the electricity power that it purchased. So the Fifth Circuit seemed to take a lot of comfort from the fact that this was not a situation in which Mirant was essentially just trying to reject these contracts and then enter into essentially equivalent contracts at lower or more favorable rates. Instead, it was a situation, as the Fifth Circuit viewed it, as one in which Mirant had to reduce the amount of its excess capacity, purchasing capacity. And it's hard to glean from the decision how crucial a factor that was in the Fifth Circuit's determination that there was no collateral attack on the filed rates. But then the Fifth Circuit went on to hold that the bankruptcy court, that it was appropriate for the bankruptcy court to utilize its powers under 501A of the Bankruptcy Code, which Cheryl described earlier, to enjoin FERC from taking any action. And then finally, FERC said in remanding the case back to the lower courts, the Fifth Circuit raised the issue that, well, maybe with regard to these particular contracts, it would be appropriate for the lower courts to not simply apply the business judgment test, but in deciding whether to allow Mirant to reject these contracts, but to perhaps apply a slightly higher standard or a heightened requirement before allowing Mirant to reject those contracts. So the court, it didn't decide what standard to apply, but it certainly encouraged the lower courts on remand to consider applying a heightened standard. And finally, the Fifth Circuit noted that FERC should be given an opportunity at the hearing on the rejection of the PPAs to weigh in and have a voice on the appropriateness of allowing rejection. So that was the Fifth Circuit's decision. And then 2 years later, we had the Southern District of New York revisit the issue in a case called NRA Calpine Corporation. And Calpine, which is a public utility company, was party to a series of PPAs under which they agreed to sell electric power to certain counterparties at rates that at the current time were significantly below current market rates. So, and we see this scenario play out in a number of the cases that we're going to, in the Calpine case and some of the other cases that we'll discuss. But the counterparties to those PPA agreements anticipated the possibility that Calpine would soon be filing bankruptcy. And in order to counteract their concern about the bankruptcy, these counterparties ran into, and ironically enough, one of these counterparties ended up being PG&E, ran into FERC and requested that FERC enter an order compelling Calpine to continue to perform under the PPAs. Well, FERC didn't the Calpine filed bankruptcy shortly thereafter before FERC had an opportunity to take any action in the proceeding commenced by the counterparties. But obviously, Calpine was concerned that FERC might take some action in response to that action, notwithstanding the commencement of its bankruptcy proceedings. So Calpine ran in and asked the bankruptcy court to enjoin FERC from taking any further action and to simultaneously authorize Calpine to reject certain of its PPAs. So again, we had a scenario in which the bankruptcy court initially entered a temporary restraining order against FERC, but once again, we had the district court withdrawing those issues away from the bankruptcy court. So the district court in Calpine ended up reaching a conclusion kind of diametrically opposed to the Fifth Circuit in Mirant. And first of all, the district court looked at the filed rate doctrine and observed that the filed rate doctrine, notwithstanding its name, doesn't just focus simply on the rates agreed to by parties to a FERC-regulated contract. It also looks at the other terms and conditions of those contracts, including the duration. So according to the district court in Calpine, a rejection in bankruptcy would obviously involve a truncation of the duration of that contract, because as Cheryl explained, rejection relieves the debtor of the obligation to continue to perform under that agreement. So according to the district court in Calpine, there would clearly be a collateral attack on the filed rate if a debtor were allowed to reject those contracts, because it would effectively truncate the duration of those contracts. Next, the district court in Calpine looked at the bankruptcy code and really found nothing in there that would support the idea that bankruptcy courts are somehow entitled to usurp FERC's exclusive jurisdiction over filed rates. And in reaching that conclusion, the district court really took a very kind of narrow view of the Supreme Court's decision in Bildisco and Bildisco. That was the opinion that Cheryl referenced, where the Supreme Court said that even collective bargaining agreements are subject to rejection. And the court read that case, the district court in Calpine read that case more narrowly. The district court in Calpine also focused on the exception to the automatic stay for governmental units seeking to exercise and enforce their police and regulatory powers. And the court drew from that additional support for the notion that FERC should really be recognized as having exclusive jurisdiction over these PPA agreements. And separate and apart from the issue of the filed rates and the collateral attack on filed rates, the district court in Calpine focused on the fact that, or on the premise that when a filed rate is established by the approval of a FERC's approval of a power purchase agreement, it not only represents a contractual obligation, but it also represents a separate and independent regulatory obligation. So that even if a bankruptcy debtor were able to relieve itself of the contractual obligation represented by a PPA, that the independent regulatory obligation established by the filed rate would continue to apply and would continue to require the debtor to continue to honor that regulatory obligation. And that's consistent with the notions of the Chapter 11 debtors still have to comply with their regulatory obligations. And the district court in Calpine drew support for that proposition from a Supreme Court case, Pennsylvania Water and Power, which is cited in the materials. So that's we had the two juxtaposing cases there of Mirant and Calpine. And then we fast forward approximately 12 years, and now we see these issues resurfacing themselves once again in some recent bankruptcy cases. And the first bankruptcy case of recent vintage to weigh in on these issues is the FERC Energy case, which was filed in the Northern District of Ohio. So in that case, it was less than a week before FERC Energy filed for Chapter 11 bankruptcy. One of the non-debtor counterparties to a multi-party PPA agreement with FERC Energy was Ohio Valley Electric Corporation, or OVAC. They, again, anticipating FERC Energy's bankruptcy filing, ran into FERC and sought a determination from FERC that FERC Energy's anticipated breach of the party's multi-party PPA would constitute a violation of the filed rate doctrine. So once again, FERC Energy files bankruptcy, and at that point in time, FERC had not had any occasion to act on the petition filed by OVAC. So again, fearing that FERC might act notwithstanding its bankruptcy, FERC Energy asks the bankruptcy court to enjoin FERC from taking any action. And simultaneously, once again, FERC Energy asks the bankruptcy court to authorize it to reject certain of its PPAs, including the multi-party PPA with OVAC. So the bankruptcy court in FERC Energy first takes up the issue of whether it's appropriate to enjoin FERC from taking any further action. And the parties, the FERC Energy debtor really requested the bankruptcy court to enjoin FERC under Bankruptcy Code Section 105A, the broad powers that are given under that provision. But the bankruptcy court said, no, I don't think started off by saying, we really probably don't even need to go there because under the bankruptcy court's interpretation, FERC was subject to the automatic stay. And they didn't see FERC as falling within the police and regulatory exception to the automatic stay. And that is because the bankruptcy court construed any action that FERC would take with regard to these particular PPA agreements as being not an action that was done to vindicate the rights to vindicate the public interest, but rather to vindicate the rights of private parties. And in that sense, the bankruptcy court said FERC would not really be acting in a regulatory capacity. So the bankruptcy court in FERC Energy determined that FERC was subject to the automatic stay. But nonetheless, as a kind of a belt suspender measure, the bankruptcy court went on to find that went on to issue an injunction under 105, just to make sure that there wasn't any doubt about FERC's inability to act in this situation. And in terms of its justification for entering a preliminary injunction against FERC, as did the court in Mirant, the bankruptcy court in FERC Energy focused on the fact that although the bankruptcy code has a number of exceptions to the rejection power, FERC-regulated contracts are not one of them. Another interesting point that the FERC Energy Court made is that they really challenged the notion that this notion that somehow filed rates, these PPAs, once they're filed, that they somehow create an independent regulatory obligation. The bankruptcy court in FERC Energy rejected that notion and said that ultimately these contracts are nothing more than contracts, and they don't give rise to any kind of separate independent regulatory obligation, such as would be promulgated pursuant to the normal notice and comment rulemaking process. Instead, they view this as really just a contractual obligation that was subject to 365. Finally, the bankruptcy court in FERC Energy did not feel that allowing rejection would in any way be a collateral attack on the filed rates. And the bankruptcy court in FERC Energy reached this conclusion by concluding that if a party stops performing under a PPA outside of bankruptcy, the FERC Energy Court's conclusion was that FERC would not step in and compel the non-performing party to continue to perform. What would happen is that the counterparty would seek a monetary claim against the non-performing party. So after entering that preliminary injunction, a few months later, the court in FERC Energy goes ahead and authorizes FERC Energy to reject the PPAs at issue. And interestingly, in allowing that rejection to take place, the bankruptcy court applies just the traditional business judgment test. So where the FERC Energy case is currently, both FERC and the counterparties to the rejected PPAs were granted permission to appeal the bankruptcy court's decisions directly to the Sixth Circuit Court of Appeals. It essentially allows them to skip a step and go directly to the Sixth Circuit Court of Appeals. That appeal has now been fully briefed, and oral argument was presented on June 26th to a 3-member panel of the Sixth Circuit, which interestingly enough consisted of 2 former bankruptcy judges. So the matter has now been fully submitted, and everyone is simply just waiting for the Sixth Circuit to issue its opinion and ruling. So that could be coming out any day. We'll have to just wait and see. So the final case that we'll address is the PG&E bankruptcy, which occurred earlier this year. This kind of case has an interesting start. So there was a California statute that was enacted last year that went into effect on January 1, and it effectively required PG&E to announce at least 15 days in advance of when it was going to file for bankruptcy. So on January 14th of this year, PG&E issued an announcement that it intended to file bankruptcy before the end of the month. This gave a number of parties that were counterparties to PG&E on PPA contracts to run into FERC and again ask FERC to issue a ruling that FERC had jurisdiction over the decision as to whether or not PG&E could get out from underneath these PPAs in the event it filed for bankruptcy. So 4 days before PG&E files for bankruptcy, FERC issues 2 companion rulings in which FERC holds that in the event that PG&E files for bankruptcy, FERC will have concurrent jurisdiction with the bankruptcy court in deciding whether PG&E can reject its PPAs and thereby relieve itself of any ongoing obligations under the PPAs. So, as we've seen before, immediately upon filing for bankruptcy, PG&E files suit against FERC in the bankruptcy court and seeks, among other things, the determination from the bankruptcy court that the bankruptcy court has exclusive jurisdiction over any request by PG&E to reject a PPA and thereby relieve itself of its ongoing obligation to perform under those PPAs. Now, interestingly, to date, PG&E has not sought to reject any of its PPAs. Nevertheless, PG&E insisted that it needed a determination from the bankruptcy court that the bankruptcy court has exclusive jurisdiction over the debtor's rejection decisions on PPAs because it didn't want to operate under the cloud of thinking that it might also have to, in its view, improperly be required to run to FERC and also get permission from FERC. And so, interestingly, though, as that issue was being presented to the bankruptcy court, PG&E simultaneously went back to FERC and asked for FERC to reconsider its pre-bankruptcy determination regarding the fact that it had concurrent jurisdiction. And on May 1st of this year, FERC issued a ruling denying PG&E's request for a rehearing and determining that and reiterating its ruling that it has concurrent jurisdiction. So after that ruling was issued by FERC, the bankruptcy court on June 7th of this year issued a strongly worded opinion in which it determined that it has exclusive jurisdiction over PG&E's decision to reject PPAs. And initially, the bankruptcy court took issue with the fact that FERC had issued this kind of advisory opinion before bankruptcy in which it claimed to have concurrent jurisdiction with the bankruptcy court. And the bankruptcy judge in PG&E, Dennis Montali, really had difficulty with the fact that FERC was deciding these issues which he thought were really only appropriate for a judicial body to determine, not an administrative agency. In ruling in favor of PG&E on the rejection issue, Judge Montali did not spend a lot of time really getting into the nuances of the filed rate doctrine. Instead, he effectively kind of assumed that rejection would be a violation or a collateral attack on the filed rates. Instead, however, he kind of, like the other like Mirant and First Energy, he focused on the fact that if you look at the bankruptcy court code, again, there is no exception in the bankruptcy code rejection powers with regard to FERC-regulated contracts. So he again drew a lot of support for the notion of his exclusive jurisdiction over the rejection power on the basis that there is no special carve-out under the bankruptcy code for FERC-regulated contracts. Judge Montali also drew some support from a earlier Ninth Circuit decision called Grunts, in which the Ninth Circuit rejected a state court's efforts to assert concurrent jurisdiction over a decision to modify the automatic stay. Now, again, because PG&E has yet to request authority to reject any contracts, Judge Montali essentially indicated that it would be premature for him to weigh in on what standards should be applied in deciding whether to allow PG&E to reject certain PPAs. But he did at least indicate that he would contemplate under appropriate circumstances perhaps applying a heightened standard and not simply the business judgment standard. So that's just to give an overview of where PG&E sits. So both FERC and the PPA counterparties that were on the losing end of the bankruptcy court's decision have sought a direct appeal of the bankruptcy court's ruling to the Ninth Circuit. As yet, the Ninth Circuit has not decided whether to allow for a direct appeal. I think the conventional wisdom is that they will ultimately do so to allow the parties to skip kind of an intermediary appellate process. Interestingly, PG&E at the same time has also sought review of FERC's pre-bankruptcy concurrent jurisdiction ruling and its refusal to reconsider that ruling. And that is the appropriate procedure that parties would follow outside of bankruptcy. That is, if you're disappointed by a FERC ruling and you've asked them to reconsider it and they deny that, then your next recourse is to ask a court of appeals to reconsider that ruling, and PG&E chose the Ninth Circuit to pursue that request. So there's probably a strong possibility that both PG&E's request for review of the FERC decision and the appeal by the disappointed parties in the bankruptcy proceeding will be consolidated and heard as one matter, but that remains to be seen. So that's kind of an overview of the four major bankruptcy decisions addressing the issue of rejecting power purchase agreements in bankruptcy.
David, thanks for that very comprehensive review of the leading decisions on this in this area. What are your thoughts about where we are now and going forward, what we might need to take into account in light of these cases?
Yeah, I think that from my vantage point, I think there's at least three issues that the appellate court. So we've got Sixth Circuit that's waiting in the wings to issue an opinion, and in all probability, we'll also have the Ninth Circuit issuing an opinion shortly. And I think that, from my vantage point, the principal issues that they're going to have to address is, first, they're going to have to consider, does a bankruptcy court order authorizing a Chapter 11 debtor to reject a PPA and thereby relieve itself of the ongoing duty to perform under the PPA, does that represent a collateral attack for purposes of the filed rate doctrine? If it doesn't represent, if the courts reach a conclusion that it doesn't represent a collateral attack on the filed rate, then I think there's a strong possibility that they're going to recognize that the bankruptcy court has exclusive jurisdiction over that decision. In contrast, if they do find it to be rejection, to be a collateral attack on the filed rates in accordance with what the Calpine court ruled, then I think there just becomes an inescapable conflict between two bodies of federal law, one being the Federal Power Act and the other being the Bankruptcy Code. And so the courts at that point are going to really, from my vantage point, are going to have to decide which law trumps the other on this question. And I think what the bankruptcy debtors will argue is that, the file rate doctrine has been around for some time, and it was certainly around in 1978 when Congress enacted the bankruptcy code. So I think bankruptcy debtors are going to argue that, hey, Congress is presumed to be aware of the filed rate doctrine when it enacted the bankruptcy code, and it obviously decided not to create a special carve-out for these FERC-regulated contracts when it enacted the bankruptcy code, and therefore, courts should honor that, and it's up to Congress if it's up to Congress to change that. But in the meantime, bankruptcy debtors should have the ability to reject power purchase agreements, and I'm sure that the PPA counterparties and FERC would take a different position on that issue, but I think that's is a pretty strong argument on the part of the debtor interests. And then I think a final issue that's lurking back there that may or may not get subsumed in the first two questions is do these PPAs, because they fall within the protection of the filed rate doctrine, do they create an independent regulatory duty that continues to apply even if the contract is no longer enforceable? And I think that's really, because if that independent regulatory duty still exists even though the contract is no longer enforceable, I think you're going to have to deal with the other issue that, we've got a statutory provision in Title 28 that requires debtors to continue to honor their regulatory obligations, and there may be, if there's this independent duty out there, then arguably debtors have to respond to it whether the contract's no longer enforceable or not. So those are the kind of the leading questions that I think have to be tackled by the appellate courts.
That's really helpful. Thank you so much for that.
So I think that pretty much brings us to the end of our conclusion, the conclusion of our presentation. We're certainly happy to answer any questions that anyone has. Okay. Well, I guess at this point it doesn't look like we have any questions, so we'll just thank everybody for attending today's conference. If you have any further questions, feel free to reach out to or email or reach out to any of us. We'd be happy to respond if you have any questions or thoughts after giving further thought to the presentation.
Thanks so much.
Thank you.